say about this topic. Just wanted to welcome everyone. My name is Diana Cohen. I am the president of the ACC San Diego chapter. Really excited again about this particular panel to have Sarah and Kyle from Higgs, Fletcher, Mack join us talking about arbitration agreements. Kyle and Sarah, I will hand it off to you. Thank you both.
Thanks for having us. It's nice to Zoom meet everybody here today. Thank you for joining us for our presentation. I get to introduce Kyle first. Kyle is a graduate of George Washington University in DC, but he started here in Coronado. He came back to San Diego for law school at USD and is now a partner here handling employment work at Higgs, Fletcher, Mack. Not only does Kyle spend a lot of time advising clients about arbitration agreements, because I know this firsthand because we share a wall, so I get to hear him talking to clients about this all the time, but he is also recently a victor in a discrimination case that was 5 weeks of trial in San Bernardino earlier this year. So he prevailed on all counts. The jury went 12-0 on every count except for one where they were 11-1. So it was a great defense verdict for Kyle and his client. So everybody, please meet Kyle Najat.
Thank you, Sarah. Yeah, I can speak after 5 weeks of a jury trial why you should have arbitration agreements and the importance of arbitration agreements in employment cases. So Sarah Evans, I think we have a slide for you, Sarah, actually.
Oh, there you go.
I can.
Oh, here, I can help.
Great.
Tag team.
Sarah is also a partner here at Higgs, Fletcher, Mack. Sarah represents businesses of all sizes, also doing some business litigation as well as employment litigation, but primarily an employment litigator. Sarah's been with us for about a year now here at Higgs. And like she mentioned, we do share a wall, so I get to hear her on the phone all the time. We got together to do this presentation because, I think everyone on this Zoom probably knows, what arbitration is, the benefits, the pitfalls, and we'll go through some of that. But, the big thing that we want to talk about is the developments that we've seen over the last 6 to 12 months in the case law here in California, and the issues that Sarah and I have both seen with our own clients and updating arbitration agreements and the importance of updating them. We are seeing a more aggressive plaintiffs bar challenging arbitration agreements, especially with the new some of the new authorities and new court decisions that have come down. And it's really important now to have everyone take a look at if you even are using an arbitration agreement or not, and weigh the benefits and the pros and cons, but also B, if you do have an arbitration agreement in place, to take a look at updating it to make sure that it's in compliance and not running into any issues with, in the event that you have the unfortunate situation that you're in litigation and your arbitration agreement is being challenged.
Exactly. First things first, a bit about our firm. As Kyle said, I just started here earlier this year, actually almost a year ago. But we are San Diego's oldest law firm. We have 14 attorneys in our employment law group and almost 80 attorneys firm-wide. So we're all on 3 floors here in lovely downtown San Diego, which is now cooling off, so that's good. So we've got people who handle immigration, who handle trust and estates, who handle corporate work, land use, but we in particular are the employment law group here and look forward to chatting with you about things today. Most notably, we please use the chat feature to send us any questions that you have about what we're talking about today. We definitely more than invite that, but encourage it, because I think that it makes us targeting for all of you who we can't see on Zoom. What information would be helpful for you to hear from us? You can let us know that in the chat. So we look forward to that. Kyle sort of gave you the preview here about why we think that this topic today is important. Obviously, arbitration impact on a lawsuit that is filed, a large wage and hour class case or pocket case or disparate impact discrimination claim. An arbitration agreement can be your best friend. So it's definitely something to consider having at your workplace if you don't already. As the second bullet point here says, arbitration agreements also allow litigation to be narrowed to just 1 year of violations on a pocket case rather than 3 or 4 years on disparate impact or the other labor code claims in wage and hour stuff. You want to go do
Yeah, and I would just want to touch on that second point again. I mean, when we're going to go through this, one of the key developments that we've seen over the last couple of years, of course, is the arbitrability of PAGA claims. And to Sarah's point, and as the bullet point says, the class action waivers in these arbitration agreements have been upheld. So those are pretty much bulletproof. And you really are able, with these arbitration agreements, if they're drafted correctly under the new authorities that we have, to limit, potentially a large statewide wage and hour class action to just a 1-year PAGA action. So instead of looking at 3 or 4 years of potential liability, you're really only looking at one. So I think that's, really a critical point. Now, point 3 that we have is it does allow you to, the way, again, you decide as a business to handle employment disputes, it allows, and there's good authority now that allows businesses to, structure the arbitrations in any way you want, which claims will be included, which claims will not. And we're going to go through that in a little more detail, but it allows you to kind of get rid of the uncertainty that we all have in litigation. And then again, on that, the last point, kind of relating to that third point, is it gives you some predictability in your employment budgets or your litigation budgets, and it allows you to, control the issues of runaway juries, runaway litigation, things that get out of control, especially with the, always impacted court system here in California.
Exactly. So while Kyle and I both look very youthful, we've been around long enough to see a very significant change in the rise of arbitration being used in our practice area. So obviously a bit of background to give you context to that is that in California employment law cases, if you're going to go to arbitration, either the other side has to agree to it or it has to be based in a contract. So you have to have an arbitration agreement to compel your employees or other people that you're engaged in business with to go to arbitration. So contracts are contracts. You guys all went to law school. You know what that is. There are 2 different provisions under our legal system that obviously impact how these contracts requiring arbitration are interpreted. California law has its own arbitration act that is in the Code of Civil Procedure, I'm pretty sure. And it has certain rules and regulations about phasing of cases that involve some claims that go through arbitration, others that need to go through the court system. The Federal Arbitration Act has its own structure for all of that. It obviously, under our constitutional system, can oftentimes be the governing factor in a lot of the case law that comes out about interpreting claims, interpreting motions to compel arbitration. So in particular, one thing to start with is because the Federal Arbitration Act is very much pro-arbitration compared to the California Arbitration Act, which is a little bit wishy-washy on it, I highly recommend, I think Kyle will agree with me, that make sure that your arbitration agreement with your employees cites the FAA as its foundational governing purpose, that this agreement is to be interpreted under the FAA, because that gives you a lot more scope and availability to compel arbitration under its very much pro-arbitration provisions. And finally, just on arbitration agreements in general, they can be part of a pre-employment onboarding process. You can even have them with your offer letter that they need to be signed there. Or while an employee is in your employment, you can talk to employees about having an arbitration agreement in place going forward. So that's basically whatever works for you. You can talk to employees about it.
Absolutely. And we'll quickly go through the next slide, which is just the benefits of arbitration. And we'll get later to some of the specific things we recommend that you do now after all those that we were talking about, we will talk about in greater detail. But as probably most of you know, we're talking about much faster proceedings. That said, Sarah and I will tell you, as outside legal counsel for a lot of companies, a lot of arbitrators are impacted almost as much as the courts. And a lot of these cases are not being set out, 6 or 8 months, but 12 to sometimes 24 months out, which, has its benefits as well in, using that delay in a settlement posture. But it does give you and the companies that you all work for a lot more, again, predictability that on this date you're going to go, because arbitrations rarely move. And as anyone who's practicing either California state or federal courts know, trials get moved all the time. And so that leads to, again, for you all, another spend that you have to go, explain to your CFO why you need to spend more money. So that is a big part of, I think, why a lot of companies and a lot of our clients do it. It's just quicker. There's privacy, right? There's nothing being filed in either the federal court system that anyone can go look at online, or, in our state court system. The runaway jury issue is huge, right? You know that it is much less likely for an arbitrator to, even if they find liability, award the claimant, especially in the employment cases that we're talking about today, significant funds, unless your facts are just really bad. And if your facts are really bad, you're probably going to go to mediation and settle beforehand anyways. So that's a benefit. And here in San Diego, yesterday, there was a jury verdict of $11.2 million in a failure to accommodate an age discrimination case. The company, I don't know the defendant employer, but apparently they didn't have an arbitration agreement or whatever. They ended up in front of a jury, and the jury found yesterday, not in downtown LA, but downtown San Diego, which is very rare for a verdict of that size. So you don't get that in arbitration. So again, avoiding those $11 million jury verdicts. And then, of course, attorney's fees on top of that, because in California, you get them in employment cases. Streamlined discovery is something that I think is one of the biggest benefits, and you can spell out in your arbitration agreements, that there's some minimums that the law requires that you provide the claimants, depositions, written discovery, but you can limit those, and arbitrators are very conducive, at least in my experience. And Sarah, you can chime in or disagree, but they're very amenable to limiting the parties to, for example, 2 or 3 depositions and 20 interrogatories. So again, you avoid that whole discovery act that we see in the CCP that can lead to just more expense for your companies. Now, of course, we touched on it earlier, the class action waivers, those are critical as part of the arbitration. We'll get to what happens if you are getting mass arbitrations and how you can handle that a little later in the presentation. And then again, tied back to the runaway jury issue, we see, and over the last decade of really the rise of arbitration, the demands that we're receiving from plaintiffs' attorneys, the minute they know that there's an arbitration agreement involved, the demands drop. You'll hear one thing from a plaintiff's attorney and a demand potentially, and then you send them the personnel file with the arbitration agreement, and all of a sudden they're a lot more reasonable and willing to talk reasonable settlement. But it's not all good.
It's not all good news. There are some pitfalls to arbitration. The discovery limitations cut both ways, in the sense of sometimes you don't get plaintiffs' records from all of their treating care providers, because sometimes an arbitrator says, you know what? Nope, we're going to keep this very narrow, focused on certain issues, and not allow discovery the way that you could get it from a judge. Same thing for securing summary judgment and summary adjudication. I have yet to see an arbitrator grant summary judgment or summary adjudication, even to narrow the claims very much.
Maybe statute of limitations.
Maybe if it's a very clear, not factual issue, they might be inclined to consider and grant the summary judgment. But in general, they're getting paid to do the hearing, so why would they not make you go forward with the hearing? I'm not to imply they don't think about it through, but I think that there is definitely my job is to hear the whole thing as an arbitrator, not to do it on the papers. And so I think that they in general take that obligation seriously, which then leads to fewer summary judgment motions than you might get in a very busy trial court in California.
And that's another cost savings for, that would be kind of a plus of arbitration,
right?
That you're not going to have to spend, as you all know, a lot of money on a motion for summary judgment.
Right. No separate statement. Everybody wins. The third bullet point here is, I think, the one that requires the most nuanced conversation. Obviously, employers in California must pay all of the arbitration fees other than what would be the initial filing fees. They can be very expensive, and the bill goes not just to me as the defense attorney, but also to the claimant's attorney. They see exactly how much the arbitrator is going to charge us 6 months or so ahead of time before the arbitration hearing. So if you have a claimant with a really terrible harassment or discrimination claim, but you get a $50,000 bill from your arbitrator 6 months before the hearing, that often sets the floor for what the settlement discussions are going to be, even if it's like I said, a terrible, terrible claim. They just know what you're going to be out of pocket to pursue the matter to the hearing, and they can use that to their effect. Whereas, hey, if you're using your state court trial judge, that's everybody's tax dollars. Oh, thanks for that question. We see a question about, are there any forum specific cons between JAMS, AAA, or any others? It's a good question. I find them all to be fairly equal from both a quality of arbitrators, from a quality of process, and from a cost perspective. When we get to the end, there's one new provider that has come on the scene that has an interesting cost structure. And we'll talk about that at the very end, of something to at least look into when you're considering revising your agreements. But between JAMS, AAA, Judicate West, the other providers, I don't think I see a substantive difference in either the rules or the process or the arbitrators.
No, I think that JAMS probably has more retired judges than AAA, if that's what you're looking for. But again, it's what does the company want to do? If you're going to get a retired judge, your arbitration is going to be more expensive. It just is.
Mm-hmm.
That's what we see all the time. They all have the employment and consumer minimums. So the discovery that we're talking about, they have to have that. Otherwise, they know that the agreements won't be valid. But cost-wise, I think that they're pretty much the same. And I agree with Sarah that procedurally they're going to be the same. And you're going to see the same time frame that we were talking about of when are we going to be setting these arbitrations? Are they going to be 8, 12, 24 months out? I don't think the provider really matters, but there is, we're going to talk about one, but there are other providers that I've been seeing here in California. I think having folks like you all recognizing that we have to pay, the employer has to pay for it, that there must be a more efficient, better way, cheaper way to address these employment, either single plaintiff or PAGA arbitrations.
So the last 2 points here of the potential pitfalls for arbitration are relatively quick to go through. It is almost impossible to join other parties. In fact, I have had the pleasure of representing a defendant in a lawsuit where the other my co-defendant, filed a petition to compel arbitration because they had an arbitration provision with the plaintiff employee. And I said, we're not a third-party beneficiary. We did not go to arbitration. They settled the case. We didn't pay a penny just because, to be honest about it, we weren't parties to the arbitration agreement. So that was a benefit for my client in that situation. But if I was the party that did have the arbitration agreement, they probably double paid for us. And the last one is limited grounds for appealing. For all sorts of good policy reasons, we don't want to have a court be the check on every aspect of every arbitrator's decision. So it can be somewhat of a black box, but that's why it's important to have a good arbitrator. And I think all of the good providers have really good arbitrators that I would trust their decisions as much as anyone in our Superior Court.
Sarah and Kyle, we do have a question in the chat. Are there any forum specific cons, JAMS versus AAA or other?
Oh yeah, I think we saw that question. We addressed it in the sense of we feel very strongly that their procedures, processes, cost, and the quality of the arbitrators are generally pretty equal amongst the ones that are well known. And then later on, we're going to talk about some of the other newer options that have less processes, but that might be a lot cheaper.
Thank you.
So next, we were talking earlier about, the importance of including the FAA in your arbitration agreements and specifically referencing it, because while we have a California Arbitration Act, that act really contemplates, and the legislature has made it clear that it contemplates, resolving and adjudicating disputes, frankly, between businesses or, in a non-employment setting. The legislature and California courts have a very negative view of employment arbitration agreements and have tried time and time again to pass legislation to limit, and we'll get into that in a moment, limit the scope and ability to arbitrate employment claims in California. And the FAA sings a very different tune, at least right now. The FAA, as we talked about at the beginning, is from the 1930s, and the courts, the federal courts, all the way up to the U.S. Supreme Court, have made it clear that it was Congress's intent that if individuals or companies or whomever, including in an employment context, sign a arbitration agreement, that their disputes, any and all disputes that are defined in the agreement, will be adjudicated in arbitration. And so time and time again, what we've seen is, California pulls one way and then the federal courts, pull the other way. And it's something that, frankly, when Governor Brown was in office, he actually vetoed some of the bills because he pretty much said, look, the federal courts are going to say that we're preempted by the FAA. So this legislation, doesn't matter. But we constantly are seeing this kind of power struggle between, and we saw it after the Viking River Cruise case, which we'll talk about, the U.S. Supreme Court and the California Supreme Court, and how do we handle, these arbitration, agreements, especially in the context of PAGA. Now, one of the big changes that, is another reason why you all need to look at and review and ensure that your arbitration agreements are up to snuff and updated, is a couple of years ago, President Biden signed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act.
Say it faster.
Yeah. Which, what it did, again, because the FAA is a federal law, Congress can, of course, then change it, even though California's tried to, the legislature. But what Congress did is they said, look, we're not going to throw all employment arbitrations out the window, but we are going to say that if someone brings either a sexual assault or a sexual harassment claim, that those claims cannot be adjudicated in arbitration, even if you have an arbitration agreement that says all claims for harassment, all claims for assault, all claims for everything. Those are now completely removed by Congress from the FAA. And therefore, to ensure that your arbitration agreement isn't challenged by a plaintiff's attorney, we recommend, robust carve outs to ensure that everyone is clear, the employee and the employer and the arbitrator who may be deciding, or the judge deciding if they're going to enforce the arbitration agreement, that these claims are excluded. And then, just ensure that you're addressing that, because again, you don't want to have someone come into court and in their opposition to your motion to compel arbitration say, well, there is no carve out here, so that you have to throw out the whole agreement, which we've seen. So that's one of the reasons that we recommend updating. We're not going to go through all the cases, but the Discover Bank and Concepcion cases are kind of the landmark cases from the U.S. Supreme Court about the power, frankly, of the FAA and the enforceability of these arbitration agreements, both in the consumer and in the employment arenas. Iskanian was a California Supreme Court case that said that PAGA claims could not be sent to arbitration. And then, of course, from last summer, the Viking River case from the U.S. Supreme Court, which threw out that Iskanian rule and said that individual PAGA claims, and we'll talk about this again, another reason to update the arbitration agreement to address all this, that individual arbitration claims can be sent to arbitration. Now, the court in that case said that—
Don't steal my thunder.
Well, there you go. I'll let Sarah talk more about those cases.
Before we get there, let's talk about the California Assembly bill that tried to make requiring employees to sign arbitration agreements unenforceable.
So yeah, AB 51, again, going back to what I was saying, there's this struggle between the FAA and California, again, both the courts and the legislature have made it clear that they don't want these employment cases to be sent to arbitration. And so AB 51 was intended to limit and frankly, completely prohibit the use of arbitration agreements for employment disputes. You could still use arbitration agreements for other disputes, landlord, tenant, real estate deals, business to business, but in the employment context, you couldn't. And it actually made it a crime that if you tried to enforce an arbitration agreement, you could be criminally prosecuted by district attorneys. That was challenged in court, and the Ninth Circuit said no. And it went up to the Ninth Circuit a couple times, back down to the district court. There was some back and forth procedurally. Then the Ninth Circuit en banc said, no, the FAA preempts AB 51, not just the criminal part of it, which was the original Ninth Circuit decision, but all of it. And what it essentially said is the supremacy clause and the Supreme Court precedent, including the Discover Bank case and Concepcion, the court has made it clear that Congress said we want these claims to be arbitrated, and so we're going to enforce the FAA over California's, frankly, objection.
So basically what that means is that the labor code provision that was designed to prohibit making signing an arbitration agreement a condition of continued employment or for starting employment is now no longer on the books. So you can require it if you want to, which isn't to say that making it voluntary doesn't also seem like a really decent idea. Most employees will sign it and not ask any questions. And if you've got 95% signing a voluntary one, I don't worry too much about the last 5%. If it's not a requirement, that's just a decision for you to make internally at your organization. Do we want to make it mandatory or do you want to make it voluntary, assuming that most people will go ahead and sign it? It's up to you and your organization.
But no one's going to jail now if you compel it.
All right. Here's my thunder. Not just kidding. As Kyle started to talk about 2 years ago, I think it was two summers ago, our world changed. As it turns out, while I was on a vacation where we didn't have cell phone access for a week. And so I came back to an entirely brand new, brave world, to the Viking River cruises. So it was also ironic that we were on a cruise. In the summer of 2022, the United States Supreme Court overruled California precedent that said that PAGA cases could not be compelled to arbitration. Basically, what the Viking River cruises holding is that if an employee signs an arbitration agreement sending his or her own claims to arbitration, that can include his or her own individual PAGA claims, not those for other aggrieved employees. So since Viking River Cruises, an employer who has an agreement that includes in its scope of arbitratable claims, I can never say that word very clearly. If it includes and encompasses individual labor code violation claims, wage and hour claims, or anything of the sort that could be interpreted to include PAGA claims, those individual PAGA claims can be compelled to arbitration. And then in the Uber case that came out, I think about 12 or 14 months after Viking River Cruises, the California Supreme Court basically said, all right, we agree, you're right. We will agree that the individual claims can be sent to arbitration, but once that arbitration is done, you got to come back to Superior Court in California to litigate in our trial courts your claims on behalf of the other aggrieved employees. So hand in hand, what that basically means is we got a two-stage process for dealing with claims. If you as the employer decide to compel arbitration of the individual PAGA claim, you can require the claimant go to arbitration first, and then end up back where the former claimant, now plaintiff, is back in court on behalf of the aggrieved employees for that PAGA claim prosecution.
And what's so critical about that, and we're going to talk about changes to the PAGA that just came down in June, but even for cases that were filed prior to June of this year, essentially what you can do now is go to arbitration, win, and then the PAGA case goes away because that person, that claimant in arbitration, has to prove at least one labor code violation in order to be aggrieved. If the arbitrator rules that the person was not aggrieved as to any labor code violation, they're no longer an aggrieved employee. They can't represent the others. And then you can just dismiss, frankly, the other, PAGA claims for the absent aggrieved employees in court. And it looks like we might have another question.
Let me pull up our chat here. Does the trial court claim get automatically stayed pending arbitration of the individual claims? Not automatically, but it's a pretty easy last paragraph before your conclusion of the petition to compel arbitration to say, and by the way, you have to stay this until resolution of the individual claims. I've not had any issues with getting a trial court judge to agree to stay the rest of the POGA claim pending the individual arbitration for the obvious reason that we don't know what we are trying to deal with in the group representative action until we go forward with the arbitration. Has that been your experience as well?
Correct.
And I haven't had any plaintiffs counsel fight it. If they're going to stipulate to going to arbitration, they will also stipulate to a stay of the other claims.
That's been my experience. But again, another, and we'll get to this, but that's another update point for your arbitration agreements. You can address this, and we are addressing it in updated arbitration agreements since the Uber case came down, which specifically talks about your individual POGA claim will go to arbitration and your non-individual or representative POGA claim will be stayed. So if you have that in the language of the arbitration agreement, that is just, further, frankly, they can't move forward because you've already agreed pre-litigation that those representative non-individual claims will be stayed. But even if you don't have that language, to Sarah's point, I've never seen a judge say, no, you have to litigate on parallel paths, the individual claim in arbitration and the representative claim, because frankly, that just would be a waste of a lot of resources in the event that we win as the employer in arbitration, and then the person can no longer prosecute the representative claim. So I don't think judges would have any issue with that.
One other thing to note that's not on the slide here, but I think that these two cases have had a very dramatic impact on the actual amount of arbitration claims being filed with AAA, with JAMS, with all the other arbitration providers. They are all crazy bananas busy dealing with these types of pre-POGA representative action individual POGA claims. So if delaying the inevitable is beneficial and you have an arbitration agreement, great. Now is the time to file your petition to compel arbitration and move things out. As you're making a decision for each different circumstance, there might be some times when you want to just move forward. We feel really good about our policies. We don't want to wait 5 years to have both of these two processes go forward. So maybe you don't compel arbitration. Maybe you just decide you want to stay in Superior Court and get this over with, rip off the Band-Aid. That's the decision to make in the moment based upon all the factors that go into making every type of strategy decision. But because this has been in place for the last 2 years, we are seeing a huge wave of individual wage and hour cases being sent to arbitration, and then it has a dramatic impact just on the timing of it into a hearing.
Yeah, and to that point too, if you have a case where at that point the plaintiff, they're not the claimant yet because we're still in Superior Court if they have filed there, if they don't agree to stipulate to arbitration and you have to bring that motion to compel, depending on the county you're in, that motion might not be heard for 6 months. And there's an automatic stay of the litigation, when you file a motion to compel arbitration. So that is yet another delay tactic to use to, again, initiate settlement, go to mediation, do some informal discovery, things like that, to see if you can resolve it before you're even having to expend any significant funds in actual litigation, either in state court or in an arbitration form.
Yep. It gives us more control over the timing, which is obviously a point of leverage that we can all use to our best advantage. Let's see, the next slide is about actually mostly just some recent decisions that really should cause you to each go back to your arbitration agreements that you have in place and make sure that they are compliant with some of the new case law that's come out, really looking closely at different issues that actually, to be honest with you, I see a lot in arbitration agreements that we look at and try and use to compel parties to go to arbitration. So,
and just if I can jump
Yeah,
in,
please.
I think what we're seeing through the Hasty case, and we'll talk about some other cases, is you're seeing after Viking River and after Uber, the plaintiff's bar becoming incredibly aggressive and trying to come up with additional arguments to attack arbitration agreements. And I'm seeing, frankly, pre-Uber, pre-Viking River in non-PAGA cases, and let's just say a discrimination or retaliation or failure to accommodate case, plaintiffs were much more amenable to just stipulating to arbitration when you presented them with the arbitration agreement. Now, because frankly, their world has kind of been shrunk by the U.S. Supreme Court and kind of by the California Supreme Court and Uber, but really in Viking River in the PAGA context, they're coming up with new ways to attack. And so that's why these next slides are kind of, we spent the first half hour giving you some background. These are now, here's your homework, points that you want to really consider, because I don't think that this is, doesn't end here. And this is why it's also important to consistently be updating your arbitration agreements, because again, they're gonna be attacked in any which way they can. And because we're in this context, the California appellate courts, because of their view of arbitration agreements in the employment context and the negative view of them, frankly, they're going to find ways to, frankly, not enforce your arbitration agreement. It's why it's so important to make sure it's updated.
Correct. So in this Hasty versus the American Automobile Association, the trial court actually had a evidentiary hearing to address the questions of whether the agreement that Ms. Hasty signed was both substantively unconscionable and or procedurally unconscionable. So that goes back to the 2000 ruling in Armendariz, which required that the courts look at both of those two different issues in two different ways. So in the Hasty case, the judge found lots of problems. Some of them that you can easily fix. Actually, all of them you can usually fix as long as you know what they are. So from the substantive unconscionability perspective, the judge said that the confidentiality clause in that agreement was overly broad in the sense of, obviously you can have NDAs with your employees, protecting your trade secrets, all the other types of things, but from a disclosure of information that is otherwise disclosable, it's really something you don't want to include in your arbitration agreement, anything beyond what is, obviously protectable for your business interests.
Including the fact that the employee has filed a claim.
Right.
You can't restrict their ability to go talk to, if they're a former employee, maybe former friends or former coworkers,
right.
and say, I filed a claim. The limitation on that has been thrown out as against public policy.
Yep. Can't ask an employee to, in your arbitration agreement, to waive their claims to be a party in a representative action. They can only force arbitration of their individual claims, but that kind of makes logical sense to me. You cannot, in your arbitration agreement, limit an employee's right to file with, say, the EEOC or with the California Civil Rights Department. They can still file those. They just maybe that government agency route has to still be open to them, in addition to either arbitration or otherwise. And then this is a practical tip to make sure that you check, but it's also part of the substantive unconscionability result here in the Hasty. If you have a link or a web address or a hyperlink in your arbitration agreement to the rules of the arbitration forum that your agreement says you're going to use, make sure they work, because here it didn't. It went to one of those, what is it, error pages. And so that was deemed to be a substantively unconscionable thing because the employee couldn't check to see what rules were going to apply before signing the agreement.
Yeah, AAA or JAMS or whoever they were using had moved the rules. Apparently.
It happens.
Yeah.
So make sure that yours works before you send the link to your next employee who signs one. The procedural unconscionability aspect of this was another thing that is a practical tip that is really easy to fix if you don't have it already in place. In the AAA's arbitration agreement, it was a link that the employee could access when onboarding, had to choose to look at the arbitration agreement. And then there was another link where the employee clicked to sign that said, I acknowledge I have read, reviewed, and agree to the arbitration agreement. It was separate from the actual arbitration agreement itself. And there was no footprints in the data, the metadata, to indicate that Ms. Hasty had actually looked at the agreement. And the court said that if you don't make the employee look at it, you can't make the employee sign it and then have it be enforceable. So that was a procedurally unconscionable issue with their arbitration agreement. So for
easy fix, though.
Easy fix.
Yeah.
Yep. So I think both the non-working link on the arbitration rules and the just making sure the agreement is there are both really easy fixes, but you want to make sure that that's in place.
Yeah, and in this case, the AAA had a severability clause that said, if any clauses within the arbitration agreement are not up to snuff, if you will, then the rest of the agreement will survive. But the court said that the issues that we've identified and the stuff that we all need to have your companies and employers look at, those issues were just they permeated the agreement to in a way to make the agreement just unenforceable completely.
And having read it recently, I think it was more based upon the fact the employee didn't even have to look at the agreement before
Correct.
signing it. That was what permeated it with unconscionability, because that meant the employee didn't even see the severability clause to lead to that different outcome there. So I think that those fixes should be, if you have that issue, fix it right away.
It doesn't, though, say anything about, you have to have a wet signature or anything like that. You can still use electronic, acknowledgements, and the onboarding systems that, most of you all probably use are through some online portal. But the important thing is they actually, and it could be a PDF, but they actually see the agreement.
Yep. Go lawyers. It makes sense. Like, I don't actually have any problem with that being the requirement. So a more recent case that came out actually gave effect to the severability clause and sent the case back down to the trial court for determination if we sever the unconscionable parts, can we still enforce the arbitration agreement? Which obviously is not where you want to be from a procedural enforcement of your arbitration agreements, but it's better than nothing, I guess.
Yeah.
So the court in this Ramirez versus Charter Communications case found that the case, or that the agreement was, I think, unconscionable on 3 grounds. So the first is that the claims that the employee was required to send to arbitration, according to the agreement, were more extensive than the ones that the employer was required to send to arbitration under this arbitration agreement. So excluded from those that the employer was required to take to arbitration were things like enforcement of our trade secrets, enforcement of our intellectual property rights. And the court said that if you want to use arbitration for everything, great.
Yeah.
If you want to divide and conquer, it has to be something that is equal for both sides. So if the employee had trade secret rights to enforce or IP rights to enforce, it might have been a mutual thing, but it can't be, we have to enforce all of ours you have to go to arbitration for all of yours, but we only go to arbitration for all of ours. It has to be a mutual thing. So if you want to exclude any claims in an agreement, which is one of the things we wanted to at least put in the be in your bonnet about, then it has to be a mutual exclusion, not only for good for us. The others that in the Ramirez arbitration agreement, they limited the statute of limitations from 3 years to 1 year. The court said that's kind of a lot to limit. So the court didn't say that 1 year, or that you couldn't limit the arbitration, or you couldn't limit the limitations period. The court instead said it has to be a reasonable limitation, and 1 year is not reasonable. So I guess it's still out there what is reasonable, but not a third of the time in the limitations period.
And I think if I can just jump in. My recommendation to clients is I think you need to stick with the legislative, set statute of limitations, because you may be in a situation where, let's say the statute's 3 years, and you limit it just to 2 because you think that's reasonable because 2 is closer to 3 than 1, but then a court's going to come in and say, well, no, nothing's reasonable if you deviate from the statute set in by the legislature.
Right. But for sure 1 year didn't work.
Yeah.
The other one the other aspect of the law that this Charter Communications arbitration agreement tried to change was the recoverability of attorney's fees if Charter Communications itself prevailed at the arbitration hearing or at trial. As you all probably know, under FEHA, there is a very high burden for a defendant to prove in order to get prevailing party attorney's fees on a FEHA claim. The employee just has to prove they won. The employer, this better than I do from your recent trial, but it's an incredibly high burden. And
very high.
The arbitration
you have to show
agreement
that the claims at either at the onset of litigation or at any time during litigation were objectively frivolous, which is incredibly difficult to prove.
So they basically tried to contract around that that requirement, and the court said that was also unconscionable. The other thing that they Charter Communications included that the court used to send it back down to the trial court to decide if they could sever these unconscionable ones from the rest was the discovered limitations that were in the Charter Communications agreement. So I think it limited just to a certain number of depositions and those types of things. And the court said that might be okay. Kind of depends. So go back down to the trial court. So we'll see how that shakes out, but definitely don't have an unreasonable statute of limitations. Definitely don't try and change the requirement for winning attorney's fees at the end of an arbitration hearing.
Yeah, and the pre-arbitration procedural requirements are also something that we see a lot in very old arbitration agreements.
Right.
If you see a personnel file that someone signed an arbitration agreement, let's say in 2005, and they just haven't signed any updated agreement, a lot of times those agreements will limit the statute of limitations, will limit when you can file, will say, before you can file an arbitration, which you have to do within 90 days of whatever happened, you have to go to mediation first with our HR person and then with an outside person, and then you can file. The court pretty much said, no, you can't limit any of that. You have to make it pretty much like they're filing in court, that there's no employer-employee pre-litigation, settlement conference, if you will, requirement. If someone wants to bring a claim against you, either in court or under the arbitration agreement, they just need to be able to file. You can't set any hurdles to that process.
And a last practical point on this slide before we move on, make sure that your arbitration agreement has this incredibly valuable clause allowing for severability of unenforceable provisions. This case from just a couple months ago makes it very clear why that's a really good idea. Not all agreements that I see that were even ones that were drafted in the last 2 years include that provision. And it can be my best friend in a motion like this. So I make sure that you've got that in there. And if not, make sure you add one going forward.
Awesome. So, we've been talking a lot about, the updates and the changes that we've seen over the last 3 years. But what do you do now, right? Now is the time to take these most recent cases, including the Ramirez case, like Sarah mentioned, from July, just 2 months ago, and take a look at your arbitration agreement. Ensure that those pro-employee provisions about discovery, about the rules, about how they can file, about making sure that we're paying for everything, all those provisions are included. How to deal with these sexual harassment and assault claims and removing them from the arbitration forum, but also addressing if you have non-sexual assault or harassment claims, how those claims can go to arbitration and the other claims are stayed pending that outcome. Again, there's a lot of things you can do to structure your kind of procedural part of your arbitration agreement to talk about, okay, if you bring, the kitchen sink and that includes a sexual harassment or assault claim, those claims, while we acknowledge will be adjudicated by a jury in Superior Court, they're stayed until we've dealt with the sexual assault and harassment claims, which then can lead you to, from a business perspective, use that, again, delay as a bargaining chip in trying to resolve all of the claims. Just because they're not in the arbitration and stayed, in a mediation or in a settlement discussion, you can resolve everything all at once. Again, how to deal with, what Viking River and the Uber case said on these PAGA claims and how to be most efficient. And we're going to talk in a moment about the updated PAGA rules. Address mass arbitrations. For example, okay, if we get 20 arbitrations, employment arbitrations, wage and hour, individual claims because they can't bring a class because of our class action waiver, how do we handle that? And you can add language to your arbitration agreement that says, if we within X number of months receive X number of arbitrations of the same claims, we can combine those in the arbitration and things like that, and you can deal with it that way. And then again, taking a look at some of these new providers, looking beyond, and of course we can't endorse anyone, but looking beyond AAA and looking beyond JAMS and kind of the traditional places that we go, because again, you can decide, and the courts have been pretty consistent, you can decide what rules you're going to follow and what provider you're going to go to if that provider, which they all do, have the minimum procedural standards to protect the employee. And you can do that in a way, in looking at some flat fee models that some of these new providers are coming up with. And I think that we're going to see more of them and more competition. To Sarah's point, JAMS and AAA are overwhelmed. And I also think JAMS and AAA will probably have to change their model to address, some of these new providers. But those are all things to think about when updating your agreements.
Right. So if this new era ADR is just one of the pioneers in this. And so we have not used them before. We have not even recommended that any of our clients include them in as the provider in their agreement, but they are out there, and that we expect to see more and more of those types of things. So if you want to check them out.
Yeah, they've got a website with a PDF that spells out if it's this type, they have different levels of cases. If it's this type, here's how much you're going to pay. And that's it. No matter how long the hearing is, no matter how many, discovery disputes you have, the arbitrator's not going to be charging by the hour. It's a flat fee. That's what you're paying. And it really streamlines things.
Which then takes some of the leverage of negotiations based simply on the cost of moving forward off the table. So it's at least worth looking into. And if you have any information about them, let us know. I think
We probably skip
oh
that.
yeah, we probably skip. I think we've already talked about this one enough. But we wanted to end here in our last 8 minutes or so with sort of thinking about these arbitration issues in the context of the recent PAGA reform. You guys have probably had your inboxes inundated with information about it. So we're not going to go forward with all of that. But to the extent that arbitration agreements and this PAGA reform can go hand in hand, we thought that would be a good spot to end on here today.
Yeah, so in June, well, let me take a step back. Before, in the spring, earlier this year, before the legislature got involved in June, the Cal Chamber and a couple other business organizations got together and were putting on the ballot in November a PAGA reform bill. The plaintiffs bar, got involved, and I think that they were concerned that was going to pass and that was going to dry up the PAGA, because there was going to severely change what types of claims. Frankly, it wouldn't be collective claims anymore. It'd all be individual claims. And so they got with the governor of the legislature and they passed the PAGA reform bills. The big thing for me, and what I've been telling my clients since it went into immediate effect, I should make that clear, and it only impacts PAGA cases that were filed after the law was passed. So if you have a currently pending PAGA case, you can't use these rules. However, I think you can use the new rules as leverage and settlement, because I think judges who get to decide what your PAGA penalties are going to be will look at these changes and realize, well, the legislature doesn't really want to punish these employers the way that we were before.
100%.
But the biggest takeaway is these audits. What you want to be doing is you want to now, before you receive a LWDA letter, before you receive a lawsuit, before you even receive a letter from a plaintiff's attorney asking for a personnel file, you want to do a wage and hour audit. You want to look at all of your non-exempt employees in California. You want to see if you have any non-discretionary bonuses that you're paying that aren't included in your regular rate. You want to look at your rest breaks, your meal breaks, your overtime, all those policies. Run sample, I'm not saying you need to do it for everybody, but run sample pay data and time data and make sure, are there rest breaks that aren't being taken at the right time, or meal breaks or the like? Are you seeing a lot of rest break premiums in certain locations if you're a major retailer or maybe a company with a lot of offices in California, and address that? Because if you do and you show that you did that, you can reduce your PAGA penalties now under the new statute by 85%, which is just an incredible
Easy money
boon for the companies, for employers in California. Another big thing, again, not so much that you need to worry about in the context of an arbitration agreement, but you get early mediation. Employers now can immediately go into the Superior Court and say to the judge, we want you to stay the case. We want to go to mediation. We want to resolve it. So that helps. And now in the context of the arbitration agreement, the standing issue, the third bullet point, is huge, because as we discussed under Viking River, the individual PAGA claims must now go, if you have an arbitration agreement, to arbitration. And if let's say the person brings a meal and rest and overtime claim,
all the kitchen sink stuff,
yeah,
right?
and you defeat them on everything but one, let's say they prove a rest break violation, under the old rules, they could still prosecute all labor code violations on behalf of everyone else in California. Now they'd only be able to prosecute that rest break claim that the arbitrator found they suffered. And then the big thing also, it ends getting PAGA penalties for derivative claims, for example, wage statement violations that were only occurring because someone wasn't getting a rest break or meal break premium.
Yeah. So it's a solid reason from our perspective to enforce your arbitration agreement so you can limit where things are going. And I see a couple of questions in the chat. So I think that our next slide is just, I think we already talked about all this, why this is all important. Hopefully our themes have been resonating with you guys, that arbitration agreements can let you have much more control over the claims against your company and the budget that you're going to need to battle them. So I think they can be a great weapon in that.
So we had a couple questions, I think.
Yeah. All right. Questions. The first one is, can you create an umbrella exemption of unless otherwise required by law or an arbitration provision? Absolutely. I think that is 100% a wise thing to do. One of the things that we didn't put in our presentation, but we actually talked about a little bit, was there might be a scenario in which you want to have a mutual limitation of claims that can't be brought. Let's say I'm trying to think of a good example, but I mean, obviously sexual harassment and assault claims are now not subject to being compelled to arbitration. But what if you're also like, feel pretty good about our age discrimination issue, so let's also not compel those to arbitration? That might be something you would exclude from your scope. But otherwise, if you just want to say umbrella exemption, we agree to arbitrate everything we can, and we agree not to arbitrate anything we can't, like that's probably a really good scope.
I think so too. However, I wouldn't lean on that if the law changes as not an excuse, but as justification for not updating your arbitration agreement to address specific things. Should Congress continue to amend the FAA like they did with the sexual assault and harassment claims, if they decide now age discrimination is going to be excluded, you'll want to, I know it's a burden, but you'll want to go back in and specifically address excluding those claims that, should Congress or the legislature say, are no longer arbitrable. And
the last question up here, and thanks, by the way, everyone, for your questions. That makes it much more fun for us, actually. Yeah. Can the audit results be kept away from litigation, confidential and discoverable? I think that's not yet been clear, and the statute, I think, is silent on that.
It is.
I think that's probably a strategy decision to make. I mean, if the audit results are terrible and you fix it, then you just want to show that you fixed everything and you don't have any problems before. If, on the other hand, the audit results are great for you, then you might consider disclosing them.
Well, actually, I think it's for both. If you have a company, now, if you're going to do it and you just want to figure out where you're messing up and not fix it, then yes, you'd want it to be under attorney-client privilege, and you want to hire outside counsel to do the audit so that it's all privileged. But even if the law is pretty clear, even if you've got a bunch of problems, let's say you never pay rest break premiums and you never give everyone a rest break, if you fix that and go back and pay everyone for during the statute of limitations, which is only 1 year under the PAGA, and you fix it, you cure it, that's the buzzword in the statute, you want to show that to the other side. You want to show the judge, look, we had a problem. We owed, $100,000. We paid the $100,000 to all the employees. Here's all the updated wage statements. Here's the declaration that shows that we, are now in compliance. Here's the new policy. Here's how the training. You want to show that. And I'm not sure if a declaration from, a HR person will be enough. Now, that would be where I'd recommend we start to see if the court will accept that, just so that you can keep those, audit findings to be as confidential as you can. But if you find problems and you show the court you fixed it, they can't go back and get PAGA penalties for those problems. So even if you find major violations, if you cure them, then it's frankly get out of jail free card.
Yep.
So I think, long term, we're going to probably want those audits to be discoverable, and you want to turn them over.
That's right.
If you fix them. If you don't fix the problem, then you'll want to keep it privileged.
Hey, thanks everyone for your questions. Thanks for your attention. And if you have any other questions, the last slide had our contact information. We're happy to help.
Yeah, thank you all, and have a nice afternoon.
Thanks. Oh, hey, Peter. Thank you.